Hello, everybody.
A question. One the defendants on one of the evictions. Sorry. Oh, sorry. I was just filed a motion to recuse Judge Shepard. We can move forward with that, right?
Yeah.
Okay. Let's make it. Okay. Unlucky for him, I don't think he realized that it's Judge Shepard. But anyways, here we go.
In which case was it, you remember? All right, the next case is cause number C1CV 240052224, Donna Keith versus Delbert Royce Hall. Persons that are affiliated with that case, would you announce your appearance for the record?
Your Honor, I'm Madeline Taylor on behalf of the plaintiff, Donna Keith, executor of the estate of Donald Alfred Hall.
All right. Do we have Delbert Royce Hall here?
I see a device that says Royce, but they haven't turned on their camera or their audio yet.
All right. That might be him. Thank you.
I'm here.
Right, Mr. Hall.
Can you hear me?
Yes, I can hear you. Can you hear me?
Yes, sir.
All right. We're going to conduct your hearing. Ms. Taylor is representing the plaintiff. Because it is a de novo hearing, the burden shifts back to her to prove her case up here. Who are going to be witnesses in this case, Ms. Taylor?
My client, Donna Keith, her listing agent, Pamela Wormley, and myself for attorney's fees.
All right. Are you going to testify, Mr. Hall?
I am.
All right. So could I ask all the persons who are going to be witnesses in this case to raise your right hand to be sworn? Do you and each of you solemnly swear or affirm that the testimony which you may give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. You may proceed, Ms. Taylor.
Your Honor, my client is the appointed executor of the estate of Donald Alfred Hall. This estate is currently pending in the Travis County probate courts, and the property at issue is held by the estate, which is the property is located at Imperial Drive, Austin, Texas. We are here today because Mr. Delbert Royce Hall, who is one of the heirs, is currently living at the property and refuses to leave, despite a clear order from the probate court requiring that the property be sold. Plaintiff is seeking an eviction of Mr. Hall under her legal authority as executor and her duty to take control of the estate property, safeguard it, and carry out the probate court's directives. To reiterate, the probate court has issued an order determining that the property cannot be divided and has directed the executor to sell the property. However, Mr. Hall has actively interfered with that court-ordered sale by refusing to vacate despite receiving proper notice. He has made unauthorized modifications to the property, thereby damaging the property. He has made unauthorized attempts to sell the property and lease the property, which has caused the estate to incur attorney's fees and issues with title. He's made it difficult to show the property to potential buyers and has even scared people off, according to the testimony that you'll hear today. As this court knows, the probate court does not have jurisdiction to remove someone from possession. That power rests squarely with this court, and that is why we're here. Ms. Keith cannot fulfill her duties as executor if Mr. Hall is allowed to frustrate the administration of the estate. The Texas Estate Code entitles an executor to possession of the estate as existed at the time of death of the decedent. The Texas Estates Code further imposes a fiduciary duty upon the executor to safeguard estate assets and administer the estate efficiently and effectively. Ms. Keith is not only entitled to possession, but is required to take possession of the estate assets, protect them, and administer the estate. Mr. Hall is damaging the property and impeding the court's directive and Ms. Keith's duty as executor. Specifically, there are other heirs in this case, Your Honor, who are financially struggling and could have taken possession of this property. However, they have been complying with the court's order and have not interfered. However, they are significantly burdened by Mr. Hall's behavior and actions and are suffering the financial burden by fighting these issues that he's causing with title and possession to this property and impeding the sale of the property. So we're asking this court to issue a judgment for possession so that the state can comply with the probate court's directive and move forward with the sale of the property. Before we proceed with testimony, Your Honor, it's my understanding that this appeal was previously heard. However, my client was not available for that hearing, so that's why we're here again. I'm not sure if you were the judge who heard that previous hearing, but the listing agent testified at that hearing, and in the spirit of judicial efficiency and economy, I wanted to ask the court if you would like to hear that testimony again. I'm guessing that
Yes,
you were not
as I appreciate it, Judge Shepard was presiding that day, and
okay.
he determined that the case should not go forward at that time. And he made no orders regarding the property at that time. So you'll just have to treat it as a brand new hearing.
Okay. Thank you, Your Honor. I appreciate that. So at this time, I would like to call my first witness, Donna Keith,
Right.
executor of the estate of Donald Hall.
All right, Mr. Hall, you are what we call pro se, meaning you're representing yourself, which you have the absolute right to do in this state. However, as a pro se litigant, you are still bound by the rules of procedure, protocol, decorum, and evidence that an attorney would be bound by, particularly when Ms. Taylor is eliciting testimony from her witnesses. You cannot interrupt them at that time and wave your hand and say, Judge, what they're saying is not right. You have to make a note about the testimony, and then when you testify, then you can dispute it if you so desire. So you understand the procedure, Mr. Hall?
Yes, I do, Your
All
Honor.
right. Thank you.
Can I mention something? The sitting judge originally, which is Judge Shepard. Is that correct?
That's correct.
Okay, so you're the visiting judge?
That's correct.
Yeah, I've heard about these situations, but anyway, so I made a motion to recuse him on today.
Well, since he's not hearing it, the motion to recuse is what we call moot. It's no reason to consider it.
It may be mute, but the this process is criminal official oppression. So if you're going to do the same thing Justice Shepard was doing to me, I'm going to ask you to recuse yourself. And secondly, um, Donna Keith is about to lose her law license because of some criminal activity.
All right,
my-
Mr. Royce,
Hold
you're
on,
not-
hold on.
no, there is no hold on, sir. I am running these proceedings,
Okay, go ahead.
okay? You will be able to produce evidence and present your side of the case.
Okay,
I'm going to hear both sides before I
sir.
make any decision. I have reached no conclusion one way or the other. I'm an impartial judge sitting here listening to both sides, then applying the law to the evidence as I hear it and making a decision. So the motion to recuse Judge Shepard is moot. Your oral motion to recuse me is not in proper form, so it will not be considered. So, Ms. Taylor, you may begin your presentation of witnesses.
Thank you, Your Honor. At this time, I would like to call the plaintiff to testify.
You may do so.
Okay. Please state your name and the capacity in which you are here today.
My name is Donna Keith. I'm the executor of the estate of my father, Donald Alfred Hall.
And can you state for the court why we are here today?
We are here to enable me to go forward with the probate court's order to sell the property located at 4900 Imperial Drive. And in order to do that, I need to have my brother, Mr. Hall, removed from the property.
And is this property part of the estate being administered?
Yes, it is.
And as executor of the estate, what are your obligations toward estate property?
I am called on to collect the property, to safeguard it, to maintain it, and ultimately sell the property and disperse the funds to the heirs, including Mr. Hall.
And you had just previously mentioned that there was an order related to this property. Can you, at this time, state for the court what that order was?
Yes, there was an order by the probate court to sell the properties, all the properties in the estate, to sell and disperse the funds.
At this time, I would ask the court's permission to share my screen.
You may do so.
So, perfect. Ms. Keith, do you recognize this document?
Yes, I do.
Without going into its contents, what is it?
It is the order for sale of estate property.
And is it a true and correct copy?
Yes, it is.
I offer what has been pre-marked as Exhibit A into evidence.
Any objection, Mr. Hall?
Any objection?
I'm sorry?
Yes, there is an objection. She's going through the process of being removed as executor. So yes, I have an objection.
Well, the
And I'm-
objection is whether or not that's a true and correct copy of the order of the sale.
Oh,
that was
yes.
in
Oh, yes. Yes,
probate
that's it.
Okay. PA is admitted.
Ms. Keith, what is this order entitled?
Order for the sale of estate property incapable of division.
And what does the order say, if anything, about the property related to this eviction?
The property related to this eviction is included in the order to sale.
Does anyone currently live in the property?
Yes, Mr. Royce Hall is on the property.
And was he living in the property when the decedent died?
No, he wasn't. And just to be clear, it was a vacant lot with nothing on it at the time that the decedent passed away.
You. What steps have you taken to comply with this order?
I have asked Mr. Hall to leave the property. I have hired a real estate agent to assist me in selling the property.
And did you or someone on your behalf send Mr. Hall a notice to vacate the property at any time?
Yes, an attorney with your firm did that.
I would now like to show this my screen to the to Miss Keith. Do you recognize this document?
Yes, I do.
And without going into its contents, what is it?
It's the notice to vacate that was sent to Mr. Hall.
And is this a true and correct copy?
Yes, it is.
Okay, I offer what has been pre-marked as Exhibit B into evidence.
Any objection, Mr. Hall?
No, sir.
Admitted.
Thank you. So, Ms. Keith, is this the notice our firm sent on your behalf?
Yes, it is.
And what is the date on this notice?
July 22nd, 2024.
And do you know in what method this notice was sent to Mr. Hall?
It was sent certified mail, return receipt requested.
And in your words, what does the notice to vacate say?
It informs Mr. Hall that he needs to leave the property or legal action will be taken.
And does the notice to vacate say anything about attorney's fees?
I don't believe so.
Will you look at the fourth paragraph? And can you read what that says?
I can just barely read it. I might not get it right.
I can enlarge it for you
Okay.
if that's helpful. Is that better?
Yes, that's better. Okay.
And that is to reiterate I am asking you to read the fifth paragraph.
Okay.
to
In the
correct yourself.
event that the premises at 4900 Imperial Drive North are not vacated before the fourth day from delivery of this notice, Ms. Keith will file suit to evict you. Additionally, Ms. Keith will seek reimbursement for her attorney's fees in this matter in an amount to be determined, but no less than $1,500.
And Miss Keith, do you know when, or Miss Keith, did Mr. Hall vacate after you sent this notice?
No, he did not.
And how long did you file or excuse me, and after he did not vacate, what did you do?
We filed suit.
And how long did you wait to file suit after sending the notice to vacate?
Well, the suit was filed on August 15th, 2024, so almost a month.
Okay.
I love his sister and I feel so bad for her.
Um, what impact, if any, has Mr. Hall's refusal to leave had on your ability to sell the property?
Well, it has frustrated the sale of the property in a few ways. One is that Mr. Hall entered into a lease with Mr. W Fireworks. Mr. W Fireworks filed a restrictive covenant on the property. So now we have a cloud on the property limiting its use for 20 years. So that is impacting the sale. And I'm also going to have an attorney help us clear that up.
Did Mr. Hall have authority to lease the property and enter into those restrictive covenants?
He did not.
Um, has Mr. Hall altered the property in any way?
Yes, he has moved personal property onto the lot, including a trailer home, a storage shed, multiple vehicles, other items, and there's also a concrete slab there that that wasn't there initially.
And did he have permission to make those modifications to the property?
No, he did not.
Is the state suffering any financial harm as a result of Mr. Hall's continued occupancy?
The state is suffering because one, we're having to pay attorney's fees. The attorney's fees comes out of the money that other heirs could have and they need just to make it day to day. They need these funds. It's also harmed because perhaps the property would have been sold by now if not for Mr. Hall's behavior. So that is the harm that I see that he's causing.
Thank you. And what are you asking the court to do today?
I'm asking the court to order Mr. Hall to leave the property, to take all of his belongings with him, everything that he put on that property, to take it with him. I'm asking for reimbursement of attorney's fees. And if Mr. Hall doesn't take the items that he has brought onto the property, I'm asking for reimbursement to the estate for moving those items.
Thank you. That will be all, Your Honor. I pass the witness.
Right, any questions of this lady, Mr. Hall?
Any questions of the attorney or my sister?
No, the witness.
The witness?
Yes.
Yes. Yeah, let me just grab my documents. Yes, Your Honor. You there? You all there?
Yes, sir.
Okay.
You may proceed.
First, I want to say I have no problem moving. I moved here during COVID, and
Well, wait a minute. Say that again. You say you have no problem moving?
No, sir. It's just the time period. The time period is what I have an issue with. Yeah, I have no problem moving. The property needs to be sold. Um, but there's 12 other properties that need to be sold also. So
We're talking about this one.
yeah,
So,
but I'm giving you the reasoning why it shouldn't be a big hurry. So it's admissible. So we've got 10 to 14 properties that have not been sold, and this is the most this one is worth the most. So even though the strategy by my sister Miss Keith has been not so good, this one should be sold last to get to maybe possibly straighten out a lot of the errors that she made during this period, the last 20 years. She hasn't maintained the property. I've added electricity to this property,
well,
enhancing the value.
let's go back to what you originally said.
That I have a problem moving.
What would you think would be a reasonable time period to have you vacate the property?
Okay, well, my mother just moved to heaven around 6 months ago. So all of her assets and property are mine, even though a few of the courts are trying to block me for them. I'm going to go ahead and move in them, but they need to be repaired. And also, my 4 half sisters are attached to my mother's property because of embezzlement. So if she wants me off the property, why don't she take her name off my mom's property? We have 2 different mothers, and
That's
so
not my question. My question was,
yes, sir.
what do you think is a reasonable time frame for you to vacate? Because this has been going on at least till August of 24. That's almost 10 months.
Okay. Are you familiar with the other cases? I'm just asking. In
And
probate,
no, the other cases are not before me.
I'm just asking, are you familiar with them?
No, they're not before me. I've not looked at them. I don't know anything about them.
Okay. All right, that's fine. I just want to ask that question. But back to the original question, I have no problem moving. I do have a shed that would have to be picked up by a tractor, and it'd have to be emptied and moved to my mom's home. The same thing with this trailer. I would have to have it moved. I'm 66 years old, and I really don't have another backup plan other than moving to my unrepaired mother's home. So basically, what I'm asking is, while I'm repairing my mother's home, which, if they're heirs of my mother's home, why haven't they helped me repair it so I can get out of here? It's like a contradictory thing going on.
Well,
Uh,
Mr.
can, can I
Royce,
can I can I
let me
ask the
ask you this.
witness?
You
Yes,
keep
sir.
talking about your mother's home. Is that one of the properties that's going to, the probate court has ordered for sale?
No, it hasn't been ordered for sale. Yeah, this is my mom's estate, which is separate from my dear daddy's estate.
And as C-Rex is pointing out there, he wasn't living there when all of this started. When his mom passed away, it was a vacant lot. He decided, I'm going to become a squatter today.
Yeah, there's 2 different estates.
I see. Okay. So Mrs. Harris, I'm sorry, Miss Keith is not the executrix of your mother's estate.
No, not close, not even close.
All right.
I'm the executor of my mother's estate.
Okay. So you have the right to allow yourself to move your mobile home and shed onto that property, or you believe you have that right, correct?
Yes, sir.
All right.
I'm
So
just
how
being,
long do you think it would take you to do that? 30 days?
no,
40?
I would need longer than 30 days, Judge. What
Well,
is
you've
the
had
time?
10 months, sir.
Well, you can, if you go against me, can I appeal your decision? Because if you're not going to be reasonable, I have a few resources. Adult Protective Services has helped me a little bit about the problems that my sister has caused financially,
Well,
emotionally.
but you're not answering my question, sir.
I'm sorry.
And I'm not saying that you have to agree. I'm just asking you if there is a possible agreement that you can reach on how long it would take you to move your items.
You started off with a month, and I disagree with that. So it's going to take more than a month, and it's going to take more than a month to get my mom's house up to code. If I could get some of my inheritance money that I have not received during all of these other sales, I probably could
I
move
understand.
tomorrow.
I understand, Mr. Royce, it's chicken and egg, but why couldn't you live in the mobile home that's going to be moved to your mother's property?
That's a real option.
So,
But I don't know about the neighborhood code. If I would get fined or ticketed, you know, uh, I'm not sure about that.
all right, well, do you have any questions to ask Ms. Keith about this case?
About this case,
Yes, sir.
um, this case includes her being the executor. Is that included?
No, she's already been named the executor by the probate court. I don't have
Okay.
any authority to change that designation. My authority today is to either give her an order that she can use to evict you or to deny her that order and allow you to stay on the property. But she has shown through her testimony today that the probate court issued her an order to sell the property. So she's between a rock and a hard place on not being able to do what the probate judge told her to do.
Why?
The other heirs could go into probate court and claim that she's not doing her duty and she might be responsible to the estate. So she has to carry out her duty to sell it. And it's unfortunate that y'all are related. Not unfortunate, but I'm saying is if it wouldn't matter that you're related or not, if I were living on the property, she would have to evict me because she's testified, and I guess the real estate lady's gonna testify in just a minute, that it's difficult to sell a bare lot or piece of property when it has items on it that it is the potential purchaser doesn't want to get involved in having to evict you. That's the idea that she as seller, she has to resolve all that before a bona fide purchaser will even touch the property. So what I'm asking you is if I give her an order, she would have the ability to have that order relayed to the constable's office, and the constable would then have the ability to take that mobile home, take that house, take it off the property, place it somewhere for storage because it's not hers. She's not claiming any interest in those two items. And so you'd be running up costs that you may never get those items back. That's the draconian manner to do it. The practical way to do it is to reach an accommodation that you be allowed 30 to 40 days to vacate. And then if you did not vacate by those, then she would be able to execute the eviction judgment against you immediately.
Okay.
So do you have any further questions, Ms. Keith?
Oh, yes, I do.
Well, we need to go with this. It's been 45 minutes, so we got another case going after you, so.
Well, I don't think this case can be rushed, Your Honor. I don't think it should be rushed.
Well, it's not going to be rushed if you'll ask questions.
Yeah, and you know, the court seems as though there's a threat in this proceeding. So I'm
No,
not
sir,
feeling
I'm just telling you what the law is and
that,
what the
that's
consequences could be.
you told me it in a threatening way. You haven't listened to my testimony. You've shut it all down.
No,
Like
sir,
this
I've
was
not shut anything down. I'm asking you to cross-examine this witness. I will give you a chance to be heard when it's your time. This is not a kangaroo court. This is an open court. I am trying to be and want to be fair and impartial. But I want you have to follow procedure. So either ask this young lady questions or tell me you don't have any questions of her. One of the two.
okay. Let me see if I can get some off the top of my head. Yes, Sister Keith, have you been somewhat unfair to me and my sister, Sandy Carroll Hall?
Objection, relevance.
Overruled. You
Have
may
not.
answer.
I have not been unfair.
Okay, that's your answer. Go ahead. Next question.
Um, that's not a good answer. She
It's an answer whether you like it or not, sir. You asked her a question whether she had been unfair. She said no. Question and answer. Next
and
question, please.
she's sworn in, correct?
She's sworn in.
Okay. Well, that's some significant perjury, but I'll go on to that next question. Have you spoken to your brother through wire communications, as in a telephone? And when did you last do that?
Objection, relevance.
Overruled.
Which brother are you talking about?
Well, my brother is deceased in 2016. Did you speak to him since you brought him up?
Well, I have more than one brother. You said my brother. Which
My
brother are you
brother.
talking?
Our blood brother.
You're talking about our brother?
Yes.
Didn't you just say he's deceased? I don't understand the question.
The question is, when did you last speak with him? He died on October 2nd, 2016. When did you last speak to him regarding this issue or property issues or any issue?
When he was in the hospital, maybe a week or two before he died.
This was by telecommunications, a phone?
Yes.
Okay, you didn't make it to the hospital. Okay. When have you spoken to Delbert Royce Hall over the last 10 years, 15 years over the phone?
That is a very long time frame. I have spoken with you over the last 15 years, but I cannot tell you when. I can guess 2 years ago. It's a guess. I don't know.
And prior to 2 years ago,
I don't know.
aren't you supposed to be in consideration with the other heirs to focus on all the interests of the heirs?
So I am representing the estate, and I want to be fair to the heirs and keep them informed, but there is a limit on what I can do. And when people are suing me and making allegations of embezzlement and all kinds of things, suing the whole courthouse, that means I have to limit the communications that I have with them.
You brought up embezzlement. You don't think our sister, our blood sister, had a right to do what she did, considering your history over the estate?
Objection vague and
Sustained.
irrelevance.
Sustained.
I feel as though because you have favored our other, you're my half sister, and all of my sisters are half. I still feel that you have favored them over this property that I'm on. My sister Sandy would not have an issue with me living here until this property is surveyed and sold. But we all know that she's homeless out in Las Vegas. Nobody's made contact with her besides me. And she has not received any of her funds from this inheritance from you or this property. That was a question.
So some people have talked to her. Janie talks to her, Sharon talks to her. I have tried in the past, not recently, but in the past, to have her make arrangements for me to send her funds to her. She has never been willing to do that. She's never showed up at court. She's never filed a paper. She doesn't want to have anything to do with it for reasons I don't understand. She won't explain it to me. I've even suggested we could give the money to her sons. She won't give me any instruction on what to do with her share of the money. And I'm just hoping it's not going to end up in the court's registry because she may have a very difficult time getting it after that.
So are you not considering her schizophrenia, her diagnosed mental illness?
Mr. Roy, you're getting way off the matter, sir. That's not before me. It has nothing to do with whether or not you have the lawful right to be on that property right now, or whether or not Miss Keith has the lawful right to have sole possession of it in order to carry out the probate court's order. Ms. Taylor, do you have any additional evidence in this matter?
I wanted to call the listing agent to speak to some of the issues that have occurred.
All right, very quickly.
Okay.
May I proceed?
Thank you, Your Honor. Plaintiff would like to call Pamela Wormley Alexander to the stand at this time. Miss Alexander, will you please state your full name and occupation?
Pamela Wormley Alexander. I'm a realtor with Berkshire Hathaway.
And are you currently representing the estate in the sale of the property at issue?
I am.
When was the property first listed for sale?
It was in the spring of 2023.
Was anyone living on the property at the time you listed it?
No.
And is anyone living on the property now?
Yes.
Have you made any attempts to coordinate showings of the property with the current occupant?
I have not I have not talked to him about doing showings, but I have arrived to the property with potential buyers.
And has the occupant impacted your ability to market and show the property?
Yes. So the first thing is that he removed my sign. Then the next thing was that when I showed up with a potential buyer, the person that owned the fireworks stand that he had leased the property to approached me and told me I had to get off the property.
Have you had any buyers express concern or walk away because of the tenant's behavior or actions?
So I've had at least 3 that I've shown the property to, and then I have other people that when they drive by the property and they call to inquire, ask me about the tenant on the property, and I cannot tell them. So typically, if there's an agreement, I can say yes. Once the property is sold, they agree to get off prior to closing. We don't have anything like that in place, and I cannot tell them that I know for sure that he's going to leave the property. And so for that reason, they don't want to make an offer because they feel like they may have to end up evicting him and spending unnecessary money on the property.
Your professional opinion, is the property harder to sell because of the current occupant?
It is.
And would you be able to move forward with a sale more effectively if the property were vacant?
Yes, I think that people wouldn't walk away.
And do you believe that the current occupant is interfering with your ability to fulfill your duties as listing agent?
Yes, as I've had to call the sheriff to do a showing. And I think that's a little excessive.
And why did you have to call the sheriff?
Because the fireworks person told me to leave the property.
Okay, I believe that will be all, Your Honor. I pass the witness.
Do you have any questions of Miss Alexander, sir?
Yes. Yes, Mrs. Alexander. I don't remember any of your signs being here. They may have been disguised as another realtor sign, but I don't remember. What's the name of your company?
Berkshire Hathaway.
What was it?
Berkshire Hathaway.
Okay, well, those were little stick in the ground pull-up signs.
Absolutely not. They're $450 huge white wooded post signs.
Yeah, I don't remember anything like that being there. There was one realtor that had a sign, and after I shedded light on what my sister was capable of doing, they took their own advertisement away. And then the other one was Keller, a friend of mine, Minerva. I can't think of her last name. She had her signs on there before my sister had them removed. So in 4 years, there's only been 2 realtor signs that I know of. And so I don't think that you're quite telling the truth. Because I watched everything on this property.
The sign was installed by a local sign company. They take a picture, they have the exact date and time when the sign was installed.
Do you have a picture of it?
I don't have a photo of it, no.
Okay. And are you connected to Minerva? She said she spoke with you in regards to this property.
Is that a question?
That's a question.
When I talked to Minerva, she told me that you gave her a power of attorney saying that you had control of the property and that you signed a listing agreement with her to list the property. And when I informed her of the court orders that I had that said that Donna Hall Keith was the executor of the property and sent them over to her, she at that time on her own decided to remove the sign.
Yeah, I never showed her any power of attorney because I'm not the power of attorney of anything connected to my father's properties. I only have one power of attorney, and that's regarding my mother. So, you know, that's kind of questionable. So, she also stated that she told you that my sister is going to cut me out of all of your inherited property, and you're going to end up.
We didn't discuss that. All we discussed was the power of attorney and her listing a property with the incorrect person. That's all that we discussed.
Okay, was she a personal friend of yours? How did you even meet her?
I called the number on the sign
And that was to establish what?
to find out why her sign was on a property that I had just listed with the executor of the estate.
Yeah, she's pretty professional. She wouldn't just put up her sign if you had a sign here. Yeah, she's pretty professional.
Her sign was up first. When I drove by the property, when I was driving by all the properties that I was going to list, her sign was there. I called your sister to let her know, and then I called the number on the sign to find out what was going on. And she told me that you presented her with the power of attorney and said that you had the right to list the property. I sent over the court orders that I had signed by a judge and told her, this is the executor of the state. Unless you have a listing agreement with her, your sign needs to come down. And so she had the sign down, I want to say within 48 hours. And then my sign went up.
Well, Judge, I think I've asked Ms. Wormley. I think I've shown that there's some controversy with Ms. Wormley and my dear oldest sister.
Do you have a question, sir?
Do I have a question?
Yes. You're supposed to be asking Miss Alexander questions. I'll give you a chance to make a statement when it comes your time.
Okay. Yeah, I don't really know your format, so I'll be able to make a statement towards the end of this situation. Is that what you're saying?
Yes, sir. The way it goes is that Miss Taylor represents Miss Keith, who's the plaintiff. The plaintiff puts on their evidence, and then you, as the defendant, you get to put on your evidence. And then after both sides have presented evidence, then Miss Taylor will make a short closing argument, and then you will make a short closing argument. That's the standard procedure in every trial here in the state of Texas.
Okay. All right, back to Ms. Wormley. I really wish, Ms. Wormley, that you would remove yourself from this sale because I had a personal relationship with you. You could be a little tainted. I don't know why you would be tainted. I work for your company for free. You never paid me, but I wish you would remove yourself, but I doubt that you would do that. So my question is, if you were to continue to sell this property, what's the harm in me moving in a timely manner in relationship with my inherited property from my mom?
There's no such agreement in place.
Yeah, I'm not asking about agreement. We're asking about consideration.
Consideration of what?
It's not going to stop you from surveying the property by me being here. There's nobody to speak to me here on this property anymore. You can have this property surveyed and whatever you want to do and reappraised and all of that good stuff. I'm saying this in front of the judge. Yeah, it's my verbal contract to you or my sister that we can get this done because it's been a lot of shenanigans and you've been a major one. So is my sister, but I'm still willing to try to work with you both uh, in this particular case?
Is that a question, sir?
That's a question.
I didn't understand it.
Are you able to reconsider this time period, giving me some months, not years?
I don't have anything to do with that. I'm there to sell the property. That's it. I don't make any decisions about any of that. The only thing that I can testify to is when I showed up that I had to call the sheriff and have him stand there while I showed the property to make sure that we were safe. That's what I can tell you because that's what happened. That's what's on a police report. I don't have anything else to do with anything other than showing the property.
All right. Any further questions, sir?
But that was the people that were threatening towards you were Mr. W's people, correct?
Yeah.
You've never seen me.
Yes, it was them.
It was Mr. W's people.
Yes, the ones that told me that you gave them the lease to the property.
Yeah, I apologize for that. I told them to, I have a lot of people wandering onto the property because of where it is. A lot of, this tiny homes out here. So I apologize. I told them nobody's to be on this property when I'm visiting my kids out of town. So I apologize for that. But they wasn't supposed to be done in any type of threatening threatening way.
Any further questions, sir?
Can I ask my sister a couple of more questions?
When it comes your time again, you can do so. Not now, when it becomes your time.
Oh, okay. All right.
Mr. Taylor, you have any further questions, Ms. Alexander?
Your Honor.
Do you have any other evidence for your
Sorry, excuse me, Your Honor.
part of the presentation?
The only thing left is to testify towards attorney's fees. I'm not
All
sure if
right.
you.
Ordinarily, I'd waive the oath, but in this case, probably need to do it. So please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony that you may give should be the truth, the whole truth, nothing but the truth?
I do.
And you may proceed.
Your Honor, my name is Madeline Taylor. I'm an attorney licensed in the state of Texas. I'm employed by the Silberman Law Firm. My firm has charged $6,000 in connection with this matter, not including this hearing. I anticipate that the fees for this hearing will be in the amount of between $350 and $700 in accordance with my rate of $350 an hour. The fees incurred in this matter were reasonable and necessary as there were multiple hearings, including this appeal. Furthermore, my client is entitled to the award of attorney's fees under the Texas Property Code.
Any questions of Ms. Taylor, Mr. Hall?
Yes. You work in connection with Garrett McMillan?
Yes, Mr. McMillan was the attorney on this case before me. He was an attorney at the Silberman Law Firm where I work. However, Mr. McMillan no longer works with the Silberman Law Firm.
Okay. That created an issue for me. Is there any reason why you didn't? How long have you been? How long has it been since you replaced him?
Leave maybe 2 weeks, if that.
Did you contact me at all?
I did not.
Is there any reason why?
I didn't. There was no reason to contact you.
Yeah, I mean, I'm pro se. I needed to get prepared for this case, and because I emailed the executive assistant to Judge Shepard and Attorney Garrett McMillan, and it just the email said I can't remember what it said, but basically it said he didn't exist. So I'm thinking in my mind, there's going to be some kind of long pause or delay. So, this was kind of like a sneak attack to me, that I wasn't contacted in regarding to moving forward with this date. And the executor uh, that works for Judge Shepard had no response when I texted them earlier this week and last week. So I was really unprepared. Yeah, I was really unprepared, and I still don't realize. Again, can you tell me again why you didn't contact me?
Well, first of all, objection argumentative and improper
Sustained.
narrative.
Sustained.
I didn't contact you because I don't represent you, Mr. Hall. And this hearing was pre-scheduled before I was on the case.
Okay. Do you know that you have a bad address on top of that? This is not 4900 Imperial Drive.
What is the address?
You asking me the address? You're responsible for evicting me.
That is the address listed in the eviction petition.
That's a bad address. And even the Justice of the Peace Precinct 1 noticed that. So, but I'm not trying to create a hard time, but it's a bad address. I'm not trying to shuck and jive and get out of this. I want this to be over with. But if I'm going to be held to the same standards as you all, not contacting me in a bad address and acting like I'm some criminal. Yeah, I'm not. I'm the oldest of Donald Alfred Hall's kids.
Sir, you need to be asking her questions. I told you I would give you time to make a statement to the court, but Ms. Taylor testified to the reasonable and necessary attorney's fees that are being sought in this case.
Oh,
and,
okay. Let me get to the
and
attorney's
the nature
fee.
of around $6,800, as I appreciate her testimony. Isn't that correct, Ms. Taylor?
That is correct, Your Honor.
All right. So you can ask her questions about.
I don't think I have any more questions for Ms. Taylor. Thank
All
you.
right. Do you rest, ma'am?
I rest. Thank you.
All right. The plaintiff has rested her case. Now it's your time. You can present me evidence by calling witnesses. Now, I'm going to give you the opportunity to testify in what we call a narrative. In other words, I'm not going to make you ask yourself questions, like state your name, blah, blah, state your address. Not going to do that. You can simply say, my name is such and such. I live at such and such if you want. But you may either call witnesses and give your own testimony, or you can just give your own testimony, or you can do nothing. Your choice.
What type of questions can I ask my dear sister, Miss Key?
Well, you can call her and you can ask her questions that are relevant to this litigation.
Okay. Yes, Miss Keith. Are you seeking attorney fees against an heir to this property?
If you mean you, yes, I'm seeking attorney's fees from you.
Can you give me a figure?
My attorney is testifying to the amount.
Okay. Okay. And you think that you're by giving me attorney's fees, you think you're being in line with being the executor of this property?
You mean by asking for attorney's fees from you?
Uh-huh.
Yes, I think an executor should seek attorney's fees because you are only one heir. And the money for the attorney is coming from all of the heirs who have done nothing. So I feel like it's fair to reimburse them the attorney's fees.
Are you gonna reimburse me the $4,000 that I spent to put electricity on this property, to also raising the value of this property? Are you gonna be able to reimburse me that when I move?
I'm not.
You're not?
No, I'm
No,
not.
I'm talking about my daddy's, you're the executive of our father's estate. I'm asking the estate, not you.
The estate will not reimburse you for that.
Okay. Will you reimburse me for any of the improvements I've made to this property over the last 4 years? Let me give you examples. There's 200-year-old pecan trees here, and they're getting old. I've been taking care of them, but they're still rotting out. And when they drop uh, branches, they're big, heavy branches. Um, and I've maintained the property. It looks like a golf course over here right now if you want to drive by because of the rain. Um, I've done nothing since I've been here but to raise the value of the property, something that our father would probably appreciate if he were living. Uh, he would be anyway. Anyway, you have the ability to give me more time. That's all I'm asking. You can start your surveying, like I told Miss Alexander. You can start, I wish you would sell the other properties prior to getting to this one, so you won't really have to give me time. There's no need to be spending money on an attorney at all. Maybe I can get victim services to get that back to us. My job as the oldest living child of my father is to make everything better, not cause controversy and conflict, and that's what we need to be doing. Um, you need to come across the aisle as though you were a Republican coming over to the Democratic side. I don't have, you're my blood sister. I don't like things that you've been doing. I don't wish no harm to you. Um, but you have to do the correct thing for our father, my mother, your mother. Um, I haven't treated your mother, my stepmother, like you all have treated my mother. I know I'm just summing it all up. Um,
You
but
need to ask a question, sir.
more time, Sister Donna. That's what I need, and I will be off this property, and it will be in better shape than what it was when I came here.
Is that a question?
More time is the question, and no attorney's fees.
Well, regarding time, we are happy to give you time. It needs to be reasonable and it needs to be in the court order so that it's enforceable. What I hear you saying is you want an indefinite amount of time whenever you happen to get the other home repaired, and I cannot agree to that. As far as attorney's fees, I will repeat, you are taking money out of the other heirs' pockets, right? And an agreement here will not end that because there is a restrictive covenant on the property now, and I will need to have an attorney correct that, right? So I'm still going to be paying attorney's fees, even if right now today you move off the property. So this is why I have to ask for attorney's fees to reimburse the other heirs.
Those people, Mr. W's legal team was shut down by the both of us. I kicked them off because of the drugs and stuff they were using while on the property. They wouldn't have left. So I helped probably even more so than you because they were smoking smoke, and I saw things that speed or cocaine packages left on the property. So they had to leave. So they don't have anything to come at us in this estate about. and it's all in the police report. Yeah, from Travis County Deputy Sheriffs.
Ask questions, sir.
That is a question. So were you aware of that, Sister Donna?
Not aware of that, but I am aware that there is a restricted covenant on file in the property records of the county clerk.
Okay, well, I can do some research to get that off because I don't think it's I don't think they want to be in a covenant with this property due to the evidence that's against them. That's okay. I don't think I have any more questions.
All right, thank you,
Can't
ma'am.
think of anything right now.
Now, you may give me your testimony and make a statement. Now, what I'm going to ask you to do is Ms. Taylor has the right to object if you go into irrelevant issues. If you hear Ms. Taylor say, Your Honor, or may it please the court, I want you to stop talking so that I can hear her objection and rule upon it. That's the protocol. So you may proceed, sir. And please take a seat, sir.
I have a bad back, sir. Yeah, I have a bad back. I have a bad lot of things because of this situation.
You may present your testimony, sir, if you'd like.
Actually, I'm somewhat incapacitated. I don't know how I'm getting through this. Okay, so why are you giving me another chance to? I thought I was finished with Ms. Taylor.
No, you are finished asking your questions. It's now your turn to give me your evidence. You can talk to me, give me your statement. But if she objects that you're talking about something that's not relevant, then I need to hear that objection.
Okay, sorry, Your Honor, I didn't hear that. You know, I have a cognitive issue and I've got a back pain issue. Yeah, and I have a anxiety issue also. I think I'm performing pretty good. Have I overtalked someone today?
Not intentionally, sir, and I didn't mean to infer that. I just wanted to tell you what the protocol was.
Yes, sir, but you didn't tell anyone that. Anyone
Pardon
else?
me?
That. You didn't tell anyone else that, sir, Your Honor.
Because they're the only one that are pro se. You're representing yourself. You don't know all the rules. So I'm required to remind you of what the rules are. Mr. Hall, you're taking up your precious time.
Now this is clarity for me, so I think it's reasonable. Yeah, I'm having to represent myself in a lot of different situations, so this is a learning experience. And this is on my time. This is, you know, I'm getting evicted, Your Honor, not you. So, so my evidence, if I need to repeat it, I have no problem leaving. But a lot of my testimony is based on my dear sister Donna Keith's inaction to treat me fairly, along with my my dear sister, baby sister Sandy Carroll, and that's evidence, and it's connected to this property and other properties, so it's all relevant. So as a part of my evidence, I'm hoping to maybe receive a share of my inheritance through this sale, a guaranteed share for me and my Sandy Carroll, my baby sister, because we've received nothing from
Objection relevance.
Okay. In the ability to just focus on this property, I would hope that you, Your Honor, will not give me a break, but you know, have consideration on what I've gone through. This has been no picnic. I have no running water. All my water is poured in by hand. All I have is electricity. I have no sewage, and it's not like I've been wanting to live here. And some of the people don't seem to care. You know, I'm at a certain age. You know, if we're supposed to be blood relatives, like you said earlier, Judge, there shouldn't there shouldn't be any attorneys. I can't afford any attorney, and I don't think I would. And I don't think my father would appreciate it regarding this property. All his properties that he was engaged in never made it to probate, and he always said probate was a bad thing. But anyway, uh, so I'm seeking some great, great, great consideration from you, Judge, because my father moved to heaven in 2006 on or about January 12th. And so that's about 20 years that I've been having this anxiety over this property and the other properties. My brother, who's deceased, was much more intelligent than me. He said we were not going to get anything from my father because of the way.
Your Honor, objection relevance.
Sustained. Stick to the point, sir.
The point is let me think. You know, the point is that I do not wish for this property to be embezzled by a realtor or anyone. All six of us. Let me plug in my computer. All six of us, and not 9 of us. All 6 of us need to be sharing in the proceeds of this property and others.
Your Honor, objection relevance.
Sustained.
I would like to get a fair price on this property, and yeah, I would like to get a fair price on this property, so we can all resolve this issue in regards to Donald Hall's estate, because this is the most expensive one, and this one was the second most expensive one.
Your Honor, objection relevance.
Sustained. Stick to the point, sir.
That's all I have, sir.
All right. Brief closing argument, Ms. Taylor.
Your Honor, I just have one question for Mr. Royce.
I'm sorry. Go ahead.
If I could just really briefly. Mr. Royce, you have stated that 4900 Imperial Drive is not the correct address for the property you are inhabiting. What is the correct address?
I'd rather my sister give you that. She's the executor. She should know the address. And
Objection
like I said,
non-responsive.
Okay. You have to answer the question, sir.
The actual address is 10,002 FM 969 Road, Austin, Texas. When I moved here, I had to establish the address. I've never done that before, but when I first moved here, in order to receive mail, I don't know where that 4900 came from. That's a street that runs on the side of this property. And 4900, 10,002 FM 969 Road is the road that runs in front of this property. So I guess there's a guess to what's the front and the side. But anyway, it's been that way since I arrived here and established it.
Thank you. That will be all.
All right, brief opening statement, closing statement, Ms. Taylor.
Your Honor, the executor is not only entitled but required to take possession of the estate assets, including this property, to safeguard them. Mr. Hall is damaging estate property and has refused to vacate despite receiving proper notice. Mr. Keith, or Ms. Keith is not only entitled to possession, but must take possession, as is her duty to effectively administer the estate. The probate court has already determined that this property should be sold and has ordered it to be sold, but that order is being delayed and obstructed by Mr. Hall's refusal to leave the property and his efforts to discourage that are discouraging prospective buyers. This court is the only court that can address possession. If this court does not act, Mr. Hall will continue to undermine the probate court's order and the executor's fiduciary duties to the heirs of the estate. We're simply asking for what the law allows, a judgment for possession in favor of the executor so that she can fulfill her fiduciary duties and carry out the sale of the property. Additionally, the JP Court's judgment set the rent payable into the registry of the court at $700 a month. I was unable to confirm in advance of this hearing whether those funds were in fact deposited by Mr. Hall into the registry of the court before this hearing. However, my client asked that in addition to her attorney's fees, costs of court, and possession of the property, that the court release all of the funds deposited into the registry, and if they were not deposited, that the court award plaintiff those rental payments in the amount of $6,300 to the judgment in this matter.
All right. Have you uploaded a proposed judgment to the box?
Yes, Your Honor. And I would like to ask that the additional address that Mr. Hall provided in his testimony be added to that order.
Well, then you'll have to redo it and submit it to submission at CCAL2. Give her it'll be the same email address that you got the link from. Isn't that correct, Ms. Dennis? Same address, email address?
Yes, sir. I put it in the chat, so she should be able to see it.
All right.
Thank you. Thank you.
Brief closing statement, Mr. Hall.
Brief closing statement. Closing statement. I think this hearing was unneeded. The plaintiff is not showing any willingness. The plaintiff is not willing to show any compassion regarding this property. Nobody's perfect. And I consider this hearing or trial in controversy. I would need more time to think about it, but just my initial thoughts. Judge, you didn't ask me about an appointed attorney. You didn't ask me if I was prepared. You didn't ask me if I was unprepared. So I'm not feeling I'm going to get any type of justice today. And I'm probably going to wish or hope to appeal this situation, even though I was willing to to work with the attorney and the plaintiff. So I can't be Christian-like if other people are not being Christian-like. So that's my closing statements.
All right, very well. The court does find that the prerequisites to suit have been satisfied, that the plaintiff has proved that she is entitled to possession of the property. The court will enter a judgment of possession and eviction order to the property, showing both potential addresses in that order. Furthermore, I will award the petitioner sum of $6,700 as attorney's fees. I don't believe, I'd have to look. I think Mr. Hall signed a offer's affidavit to do the de novo appeal. So with that, I don't believe he was probably required to make those deposits with the clerk.
Can you clarify that, Judge? I didn't get
Well,
out.
Ms. Taylor at the very end brought up that you were supposed to deposit with the clerk some $6,000, I guess would be 10 months of rent at $600 a month. But I've received no evidence about the fair rental value of the property, so I can't make that judgment and enter thing in this judgment based on no evidence. So I'm simply going to deny, however you characterize that request, Ms. Taylor.
Your Honor, if I may, the JP Court's judgment, which is in the record, states that the $700 a month needed to be paid in the registry of the court to maintain possession. It's my understanding that a bond to secure an appeal is a separate issue, which, as you stated, Mr. Hall, entered in an affidavit of inability to pay.
I don't think there's any money in the registry of the court.
I'm not certain, Your Honor, but it's my understanding that tenants who are being evicted, and if they want to maintain possession of the
I
property.
understand what the law is
Right.
very well. I'm
Yes,
just
sir.
saying in practicality, I don't think it happened.
Yes, Your Honor.
Now, you might have had some procedural remedy to even avoid the de novo hearing or the defendant below not making those payments, but you've waived those. So I'm not going to make any ruling in this order that I'm going to sign concerning any funds in the registry of the JP Court. And if you'll draw that order and submit it by email. Thank you very much. You may be excused.
Hold on, Judge. Hold on, Judge.
No, there's no hold on. That's my ruling. And
Yeah, I didn't get all of it. I just got the money part.
well, no, I found for the plaintiff, I gave them a judgment of possession and a right to evict, an eviction order, and awarded them $6,700 in attorney's fees.
And what about an appeal?
Well, you as a pro se defendant, you have to figure that out. I can't practice law for you. Okay.
You're a judge, sir.
I am a judge, but I can't practice law. I can't tell everybody that comes to court how to do their stuff. The law doesn't allow me to do that. I will tell you that at the Travis County Law Library, there are at least 2, if not 3, attorneys that you can go talk to, and they can, in general, advise you about the law and they can steer you towards some type of form books to give you access to the proper forms to use. That's the best I can do for you, is to advise you of that. All right, thank you very much. You may be excused.
Thank you, Your Honor.
Thank you.
You guys are the absolute greatest. Be safe, be well, sleep sweet, and much love.